Welcome to this explainer. So, have you ever wondered if the lawyer representing your government has to play by a totally different set of rules than the lawyer representing, say, your neighbor? It's a genuinely fascinating question. Today, we're going to break down the complex and honestly, sometimes really fiery debate surrounding the ethical obligations of government lawyers versus private ones. Okay, let's dive right into this. Our whole analysis today comes straight from this really compelling academic article, Professionalism and the Public Interest. It's authored by Maliha Wilson, Taya Wong, and Kevin Hill. They dig incredibly deep into whether civil government lawyers are bound by different or maybe even higher rules of conduct than lawyers working in private practice. Here's a quick look at our roadmap. We've got law as a calling or a business, the Attorney General's role, the question of a higher ethical standard, government lawyers as public guardians, and finally, same rules, different client. Let's get started. Section 1. Law, calling, or business. The evolution of legal professionalism. Historically, practicing law, right alongside medicine and theology, was viewed as this totally selfless vocation, a noble calling devoted to the greater good. But the authors point out a pretty stark contrast happening today. The profession has become heavily commercialized. We're living in this celebrity culture where clients will sometimes totally bypass the most competent lawyer just to hire the screamers, the loudest voices in the room. And this shift makes it absolutely crucial to pin down what professionalism actually means before we can argue about who's held to a higher standard. Before we even think about exceptions or special rules for government lawyers, we've got to establish a baseline. There are strict ethical duties that apply to every single lawyer across the board. Whether you're just drafting a simple will or arguing a massive case at the Supreme Court, you have to offer competence, act with civility, and seek justice. And civility, by the way, isn't just about being polite. It's a hard, substantive requirement that makes sure the public actually keeps its confidence in the justice system. Section 2. The Attorney General's role. Defining the Crown's legal advisor. To really grasp how this whole legal structure works, we have to recognize that the Attorney General essentially wears two entirely different hats. On one hand, they're a cabinet minister, right? They represent political interests and drive government policies. But on the other hand, they are the independent chief law officer of the Crown. In that second role, they have to act totally independent of partisan politics to defend the rule of law. So every single government lawyer advising them is operating under the immense pressure of those two massive responsibilities. Handling that kind of dual pressure took a massive structural shift over the decades. Back in the late 1960s, the McClure report highlighted a really fundamental weakness in Ontario's system. There was basically zero cohesion in legal services. Lawyers were just scattered across different ministries without a unified voice. Well, that report kicked off some major institutional reforms, eventually giving the Attorney General direct control over government litigation. By 2007, this was completely centralized. And why? To ensure that no matter what ministry a lawyer happens to sit in, they are giving objective, consistent legal advice for one single client, the Crown. Section 3. A higher ethical standard. The drama of the Everingham case. All right, here is the million-dollar question. If the government's overarching job is to seek justice and serve the public, should their lawyers be allowed to exploit legal loopholes? I mean, should they be allowed to play hardball, or do they owe some kind of higher ethical duty to the citizens they're litigating against? The courts have actually wrestled with this head-on. Take the Everingham case, for example. It's quite a story. An institutionalized psychiatric patient brought a charter application challenging his treatment. A government lawyer was set to cross-examine him, but before that happened, the lawyer actually visited the hospital and spoke directly to the patient, allegedly putting out a feeler to see if the patient would drop any damaging information. Well, the patient's side filed a motion to remove the lawyer for improper contact. The motions judge agreed and made a massive claim. They said that because a government lawyer represents the public trust, they have a higher obligation than lawyers generally. But hold on, the story doesn't actually stop there. The divisional court reviewed this decision and issued a pretty sharp rebuke. They stated incredibly clearly that it is not flattering to the lawyers of Ontario to imply most of them are held to some lower standard. The court confirmed that all lawyers are subject to the exact same high standard of professional conduct. The government lawyer's behavior in Everingham was wrong, but not because they were a government lawyer. It was wrong because it breached the fundamental rules that apply to literally everyone in the profession. Section 4. Guardians of the Public. The academic debate. This split in the courts perfectly mirrors a really fierce debate happening right now among legal academics. Let's look at the theory. You have legal scholar Adam Dodek arguing that government lawyers exercise public power when they advise on the law. basically making them custodians of the rule of law itself, which to him absolutely demands a higher ethical duty. But the counterargument is super pragmatic. Critics point out the government lawyers don't actually wield public power. Elected officials do. The lawyers just advise. Plus, slapping on this vague, higher ethical duty would completely tie the government's hands, making it nearly impossible for them to operate and litigate effectively in the real world. And the Hollinger case is a perfect real-world example of that pragmatic side. In this case, applicants launched a massive judicial review to stop a provincial land exchange, basically using the litigation as a stalling tactic in an ongoing war with the province. So did the government lawyers just quietly step back to observe some higher duty? Absolutely not. They fought back aggressively. They won the case, and the court awarded them a staggering $702,000 in costs. The big takeaway here? Sometimes the public interest is best served by government lawyers playing hardball and using every single legal argument available to protect the taxpayer. Section 5. Same rules, different client. Arriving at the verdict. So how do we actually reconcile the government lawyer's unique role with the standard rules of legal ethics? The New Brunswick versus Rothman's case clears this up beautifully. The court pointed out that while Crown prosecutors in criminal cases owe a strict duty of impartiality to make sure a trial is fair, civil government lawyers don't. They definitely remain guardians of the public interest, but in a civil lawsuit, they don't have to be impartial. They are fully allowed to be zealous, fierce advocates for their side. It all boils down to understanding the client, rather than trying to change the rules. A private lawyer advocates for an individual's personal or commercial interests, right? But a government lawyer advocates for the public interest, derivatively, through their specific client, the Crown. So the nature of the daily work is different, but that core ethical baseline, it remains rock solid. At the end of the day, the source authors conclude that government lawyers just don't have some secret, separate rule book hidden in a desk somewhere. They are bound by the exact same high standards of professionalism, civility, and integrity as any private lawyer. They simply apply those exact same standards to a really unique, incredibly multifaceted client that ultimately answers to the citizens. Which leaves us with one final, incredibly important thought. The source text makes a profound point. The rule of law doesn't survive just because of grand, historic court decisions. It survives because of the quiet, everyday, unheralded choices made by individual lawyers. So, as we face a modern world where law is increasingly seen as a commercial business rather than a noble calling, how on earth do we mentor tomorrow's advocates? How do we train them to balance that zealous, aggressive representation with an unwavering duty to the public good? It's a question everyone in the legal profession needs to be asking themselves. Thank you so much for joining me for this explainer, and remember to keep questioning the structures that shape our society.